American Politics Today by Blanco Cannon, Chapter 4, Part 2. Freedom of speech, assembly, and the press. As noted earlier, defining the scope of our civil liberties depends on balancing interest and drawing lines. This is especially true for the First Amendment speech, which can be envisioned on continuum from most to least protected types of speech based on the Supreme Court cases that have tested their limits. Generally protected expression. Anytime you attend a religious service or political rally, post a tweet, write a blog, post a letter to the editor, or express a political idea, you are protected by the First Amendment. However, the nature of this protection is continually evolving due to political forces and shifting constitutional interpretations. Only recently have the courts developed a complex continuum ranging from strongly protected political speech to less protected speech. Standards for protection. The basis for the continuum of protected speech is rooted in the content of the speech. Typically, the court does not allow content-based regulation of speech unless it falls into one of the categories of exceptions we discuss later. For example, in 1972, the court struck down a local ordinance that banned picketing outside schools except for labor picketing. This ordinance was deemed to be content-based regulation because it favored one form of speech from labor unions overthrowers. Such regulation is subject to the strict scrutiny standard of judicial review, which means the regulations must be narrowly tailored. That is, the least restrictive means to serve a compelling state interest. In most cases, this means that the speech will be protected and the regulation struck down. If a regulation is content neutral, unquote, and does not favor any given viewpoint, then it is subject to the less demanding intermediate scrutiny standard. This means that the government must demonstrate only substantial interest. The interest must be unrelated to the content of the speech, and there must be an alternative opportunities for communication. Political speech. Freedom of speech got off to a rocky start when Congress passed the Alien and Sedition Acts in 1798. The controversial Sedition Act made it a crime to write, print, utter, or publish any false, scandalous, or malicious writings against the government of the United States. Supporters of the acts claimed they were necessary to strengthen the national government in response to the French Revolution, but in reality they were an attempt by governing Federalist Party to neutralize the opposition. The Democratic-Republican Party, the outcry against the laws, helped propel Thomas Jefferson to the presidency in 1800. Jefferson pardoned those who had been convicted under the law, mostly newspaper editors. Congress repealed one of the acts in 1802, and the others were allowed to expire before the Supreme Court had a chance to rule them unconstitutional. In the 20th century, World War I prompted the harshest crackdowns on free speech since the Sedition Act of 1798. The most important case from this period involved the General Secretary of the Socialist Party, Charles Schneck, who opposed U.S. involvement in the war. He had printed a leaflet urging young men to resist the draft. Schneck was arrested, and he appealed all the way to the Supreme Court, arguing that the First Amendment permitted him to protest the war and urge others to resist the draft. But the court sustained his conviction, noting that free speech is not an absolute right. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. This clear and present danger test meant that the government could suppress any speech it deemed dangerous. In this instance, preventing the government from fighting the war. However, critics of the decision argue that Schneck's actions were not dangerous for the country and should have been allowed. Over the next several decades, the court struggled to draw the line between dangerous speech and words that were simply unpopular. Then in 1969, the court established in Brandenburg versus Ohio a strong protection for free speech, superseding the clear and present danger test that holds today. This case involved Clarence Brandenburg, a Ku Klux Klan leader in Ohio, who made a threatening speech at a cross-burning rally that was subsequently shown on television. 12 hooded figures were shown, many with weapons. The speech said that revengeance might be taken if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, unquote. It continued, quote, "We are marching on Congress July the 4th, 400,000 strong," unquote. The Klan leader was convicted under an Ohio law banning sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform, unquote. But the court unanimously reversed his conviction, arguing that threatening speech could not be suppressed just because it sounded dangerous. Specifically, the direct incitement test holds that speech is protected, quote, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action, unquote. Under this new standard, Schneck and many other previous sedition convictions and limitations on speech during World War I and the Red Scare would have been overturned. Perhaps the strongest example of protecting unpopular speech comes from the case of the Westboro Baptist Church, the WBC. Since 2005, members of the WBC have protested at hundreds of funerals of members of the armed services who were killed in Iraq and Afghanistan. However, these are not typical anti-war protests. Instead, the protesters claim that troops' deaths were God's punishment for the homosexual lifestyle of soul-damning, nation-destroying filth. The church and its members have drawn strong reactions and counter-protests for the confrontational approach at the military funerals, including their use of signs that say, "God hates fags," "Thank God for dead soldiers," "God killed your sons," and "God hates America." Critics, including many veterans groups and attorney generals from 48 states, argue that the protest should not be considered protected speech under the First Amendment. The veterans of foreign wars issued a statement saying, quote, "In a time of profound grief and emotional vulnerability, the personal attacks are an affront of the most egregious kind," unquote. However, in 2011, the Supreme Court ruled 8-1 that the WBC's protests were protected speech, symbolic speech. The use of signs, symbols, or other unspoken acts or methods to communicate in political manner, symbolic speech, enjoys many of the same protections as regular speech. For example, during the Vietnam War, the court protected the right of a protester to wear an American flag patch sewn on the seat of his pants, a high school student right to wear an armband to protest the war. Tinker versus Des Moines School District, 1969. And an individual's right to tape a peace symbol on the flag and fly it upside down outside an apartment window. A 1989 case provided the strongest protection for symbolic speech, yet overturning the flag desecration law in Texas on the grounds that symbolic political speech is protected by the First Amendment. In response to this unpopular decision, Congress passed the Flag Protection Act of 1989, which the court also struck down as an unconstitutional infringement on political expression. Congress then attempted 6 times to pass a constitutional amendment to overturn the court decision, but each time the measure failed in the Senate. President Trump reignited this debate shortly after he was elected, tweeting, "Nobody should be allowed to burn the American flag. If they do, there must be consequences, perhaps loss of citizenship or a year in jail." However, Republican leaders in Congress have not been interested in revisiting this fight. Money is speech. Spending money in political campaigns may also be protected by the First Amendment, since it provides the means for more conventional types of political speech. Here the question is whether the government can control campaign contributions and spending for a broader public purpose, such as lessening the potential for corruption, or whether such laws violate the First Amendment rights of candidates or their supporters. You probably have heard the old saying, money talks, which implies that money is speech, given the importance of advertising in modern campaigns. Limitations on raising and spending money could limit the ability of candidates and groups to reach voters with their message. The court has walked a tightrope on this one, balancing the public interest in honest and ethical elections and the First Amendment rights of candidates and their advocates. The court has upheld individual candidates' right to spend their own money in federal elections, but presidential candidates give up that right if they accept federal campaign funds, taxpayers' money, in a presidential election. Also, candidates in federal elections are subject to limits on the types and size of contributions they can receive, and they must report all contributions and spending to the Federal Election Commission. The Bipartisan Campaign Reform Act, which went into effect for the 2004 elections, included a Millionaire's Amendment that lifted restrictions on campaign contribution for candidates whose opponent spent more than $350,000 of his or her own money in the election. This attempt to level the campaign finance playing field was struck down by the Supreme Court in 2008 as a violation of wealthy candidates' First Amendment rights. In 2010, the court also extended First Amendment rights to corporations and labor unions that want to spend money on campaign ads. In 2014, the court struck down aggregate limits placed on individual contributions. However, the court upheld a ban on unlimited, quote, soft money contributions because they have the most potential for corruption. Hate speech. Free speech has been a hot topic on many college campuses in the context of hate speech. Do people have a right to say things that are offensive or abusive, especially in terms of race, gender, or sexual orientation? By the mid-1990s, more than 350 public colleges and universities said no by regulating some forms of hate speech. Many of these speech codes were struck down in federal court. But in the last few years, the issue has resurfaced on many college campuses, in addition to the controversial speakers discussed in the chapter opener, A Variety of Campus Climate. Issues consumed dozens of schools at Yale University in 2015. Controversy erupted over the response of the residential college faculty administrator, Erica Christakis, to an email students received cautioning them not to wear Halloween costumes that could be racially or culturally insensitive. Christakis wrote that the universities no longer allowed students to be a little bit inappropriate or provocative or, yes, offensive, unquote. She resigned a few weeks later, saying, "The current climate at Yale is not, in my view, conducive to the civil dialogue and open inquiry required to solve our urgent societal problems. The president of the University of Missouri also resigned in 2015 after students, including the football team, said that he was racially insensitive and not open to their demands for a more inclusive and supportive environment on campus. In 2017, Indiana University students petitioned to remove part of a mural that depicts the history of the state, using imagery of a burning cross and white-hooded Klansmen. University leaders compromised by leaving the artwork up, but saying that classes would no longer be held in the lecture hall with the mural. Another significant issue combines the topics of symbolic speech and hate speech. For example, can a person who burned a cross on a black family's farm lawn be convicted under a city ordinance that prohibits conduct arousing anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender? Or is the ordinance an unconstitutional limit on the First Amendment rights? In this case, the court said the cross burner could be punished for arson, terrorism, trespassing, or other violations of the law, but he could not be convicted under that particular city ordinance because it was overly broad and vague. However, the court has since upheld more carefully worded bans of cross burning. Speech on the internet. Internet hate speech has become increasingly controversial in recent years. Cyberbullying precipitated several suicides, and then in 2013, Facebook cracked down on offensive content that glorified violence against women, such as pages with headlines like "violently raping your friend just for laughs." Facebook community standards have a more restrictive definition of hate speech than is allowed by the direct incitement test. While Facebook makes a distinction between humor and serious speech, it does not permit individuals or groups to attack others based on their race, ethnicity, national origin, religion, sex, gender, sexual orientation, disability, or medical condition. This led Professor Jeff Rosen to conclude that today, lawyers at Google, YouTube, Facebook, and Twitter have more power over who can speak and who can be heard than any president, judge, or monarch. This may sound like a hyperbole, but he is right. Corporations are not restricted by the First Amendment, which after all says Congress shall make no law. So if Facebook and other social media want to restrict hate speech, they can. Although free speech advocates are concerned about restrictions on internet hate speech, civil rights groups such as Defamation League, the Leadership Conference on Civil and Human Rights, and the National Organization for All Women all support the move. Another controversial area of speech on the internet is political ads. Late in 2019, Twitter announced that it was banning all political ads for the 2020 elections, while Google restricted micro-targeting based on ideology, party, or voting history. Facebook, on the other hand, still allows political ads, but with warnings if they are deemed untrue. While social media companies have great latitude in what they permit online, the government has limited power to regulate access to social media. In 2017, the court struck down a North Carolina law that prohibited sex offenders from accessing or using social media sites, saying that these sites are the quote, principal sources for knowing current events, checking ads for employment, speaking and listening in the modern public square, and otherwise exploring the vast realms of human thought and knowledge, unquote. Therefore, limiting access to social media would prevent the legitimate exercise of the First Amendment rights, unquote. The freedom of assembly. The Supreme Court has consistently protected the right to assembly peaceably. Perhaps the most famous assembly case involved a neo-Nazi group that wanted to march in Skokie, a suburb in Chicago whose population of 70,000 was nearly 60% of Jewish, and of those, many were Holocaust survivors. The village passed ordinances that banned the group from marching, arguing that residents would be so upset by the Nazi marchers that they might become violent. But the lower courts did not accept this argument, ruling that if the audience is so offended by the ideas being expressed that it becomes disorderly and attempts to silence the speaker, it is the duty of the police to attempt to protect the speaker, not to silence his speech, unquote. Otherwise, the right to assembly would be restricted by a, quote, heckler's veto. While broad protection is provided for peaceable assemblies, governments may regulate the time, manner, and place of expression as long as these regulations do not favor certain groups or messages over others. For example, the court ruled that anti-abortion protesters were not allowed to picket a doctor's home in Brookfield, Wisconsin, on the grounds that the ordinance banning all residential picketing was content neutral. There was a government interest in preserving the sanctity of the home, the one retreat to which men and women can repair, escape from the tribulations of their daily pursuits. Time, manner, and place. Restrictions also may be invoked for practical reasons. For instance, if the Ku Klux Klan planned to hold a march around a football stadium on the day of the game, the city council could deny it a permit and suggest that it choose another day that would be more convenient. When white supremacist Richard Spencer requested to speak at the University of Florida just a month after the tragic events in Charlottesville, the school initially turned him down, saying that it would not have time to provide adequate security for the event. However, it approved the talk for a date a month later. The legal standard for time, manner, and place regulations is that they must be reasonable. This standard came into play in a 2014 case in which the court ruled that a Massachusetts state law creating a 35-foot buffer zone around entrances to abortion clinics violated the First Amendment. While the buffer zone was content neutral, it was reasonable because it was more restrictive than necessary to allow access to the clinics, while the reasonableness standard is vague. It allows the courts to balance the right to assemble against other practical considerations. Freedom of the press. The task of balancing interests is central to many First Amendment cases involving the freedom of the press. The general issue here is prior restraint. The government's right to prevent the media from publishing or later broadcasting something of social or political significance. Prior restraint has never been clearly defined by the Supreme Court, but several landmark cases have set a very high bar for applying it. One suit brought in 1971 and known as the Pentagon Papers case, New York Times Company versus the United States, involved disclosure of parts of a top secret report on internal planning for the Vietnam War. Ultimately, the court decided that the government could not prevent publications of the Pentagon Papers, but at least 5 justices supported the view that under some circumstances, the government could use prior restraint, though they could not agree on the standard. The debate over restraining the media heated up in 2010 with the sensational leaking of more than 91,000 reports concerning the war in Afghanistan by WikiLeaks. Some members of Congress labeled the leaks, quote, treason, unquote, and called for prosecution. However, supporters of unrestrained press point to the Pentagon Papers case as precedent for the role of journalists in holding the government accountable. They argue that the conduct of war and programs such as warrantless wiretapping of U.S. citizens may violate international or domestic law, and that the public has the right to know about them. The forms of expression discussed in this section, speech, assembly, and press, all have strong protection from the First Amendment. The strongest protections are for content-based expression. However, there are exceptions such as speech that directly incites and imminent danger. If the regulation is content neutral and does not favor one viewpoint over another, then it is easier to uphold, but even then the government must have a substantial reason for limiting expression. Less protected speech and publications. Some forms of speech do not warrant the same level of protection as political speech because they do not contribute to public debate or express ideas that have important social value. Governments may more easily regulate 4 categories such as speech, fighting words, slander, and libel, commercial speech, and obscenity. The first 2 categories may be prevented by the state if certain conditions are met, and the second 2 receive some protection, but not as much as political speech. Fighting words. Governments may regulate fighting words, quote, which by their very utterance inflict injury or tend to incite an immediate breach of the peace, unquote. Such laws must be narrowly written. It is not acceptable to ban all foul language, and the prohibited speech must target a single person rather than a group. Moreover, the question of whether certain words provoke a backlash depends on the reaction of the targeted person. Inflammatory words directed at a pacifist would not be fighting words because he or she would turn the other cheek, whereas the same words yelled at a hothead would be fighting words because that individual would likely respond with violence. The court has further clarified the test based on, quote, what persons of common intelligence would understand to be words likely to cause an average addressee to fight, unquote. Slander and libel. A more extensive line of cases prohibiting speech concerns slander, spoken false statements that damage someone's reputation, defamation, and libel, written statements that do the same thing. However, it is difficult to draw the line between permissible speech and slander or libel. The current legal standard distinguishes between speech about a public figure, such as a politician or celebrity, and speech about a regular person. It is much more difficult for public figures to prove libel because they must demonstrate that the defamatory statement was made with actual malice, unquote, and, quote, with knowledge that it was false or reckless, or with reckless disregard of whether it was false or not, unquote. One of the most famous libel cases occurred when Reverend Jerry Falwell, a well-known televangelist and political activist, sued Hustler magazine for libel and emotional distress after the magazine published a parody of a liquor advertisement depicting him in a, quote, drunken, incestuous rendezvous with his mother in an outhouse, unquote. This quote is from the Supreme Court case. The court ruled against Falwell, saying that public figures and public officials have to put up such things, comparing the parody to outrageous political cartoons, which have always been protected by the First Amendment. Commercial speech. Commercial speech, which mostly refers to advertising, has evolved from having almost no protection under the First Amendment to enjoying the quite strong protection. The court became much more sympathetic to commercial speech in the 1970s when it struck down a law against advertising prescription drug prices and a law prohibiting placing newspaper racks on city streets to distribute commercial publications such as real estate guides. The key decision in 1980s established a test that is still central today. The government may regulate commercial speech if it concerns an illegal activity, if the advertisement is misleading, or if regulating speech directly advances a substantial government interest and the regulation is not excessive. In practice, this test means that commercial speech can be regulated, but the government has to have very good reason to do it. Commercial speech is protected even when it could be considered offensive. In 2017, the court sided with the Slants, an Asian American rock band, in overturning a provision of the U.S. patent and trademark law that prohibited the registration trademarks that disparage or bring into contempt or disrepute any persons, living or dead. The Slants, whose application to trademark their band name had been denied, argued that their goal was to reclaim the racial slur against Asian Americans. In the same way that the LGBTQ community over time redefined the use of queer, the court agreed, saying a law that can be directed against speech found offensive to some portion of the public can be turned against minority or dissenting views to the detriment of all. This ruling also meant that the Washington Redskins football team will be able to keep its nickname, despite the fact that many find it offensive. Obscenity. One area in which the press has never experienced complete freedom involves the publication of pornography and material considered obscene. The difficulty arises in deciding where to draw the line. Nearly everyone would agree that child pornography should not be published and that pornography should not be available to minors. However, beyond these points, there is little consensus. For example, some people are offended by nude paintings in art museums, while others enjoy watching hardcore X-rated movies. Defining obscenity has proven difficult for the courts. In an often quoted moment of frustration, Justice Potter Stewart wrote that he could not define obscenity, but, I quote, "I know it when I see it," unquote. The Supreme Court took a stab at it in 1973 in a case that gave rise to the Miller test, which is still applied today. The test has 3 standards that must all be met in order to material to be banned as obscene. It appeals to prurient interests. Number 2, it is patently offensive. And 3, the work as a whole lacks serious literary, artistic, political, or scientific value. The court also clarified that local community standards are to apply rather than a single national standard. The right to bear arms. Between 1791 and 2007, the court issued only 4 rulings directly pertaining to the Second Amendment and the right to bear arms. The federal courts had always interpreted the Second Amendment's awkward phrasing, a well-regulated militia being necessary to the security of free state. The right of the people to keep and bear arms shall not be infringed, as a right to bear arms within the context of serving in a militia rather than an individual right to own a gun. Interest groups such as the National Rifle Association have long asserted that the Second Amendment guarantees an individual the right to bear arms. Critics of this view emphasize that the first clause of the amendment and point to the frequent mentions of state militias in congressional debates at the time of the Bill of Rights was adopted. They argue that the Second Amendment was adopted to reassure anti-federalist advocates of states' rights that state militias, not a national standing army, would provide national security. In this view, the National Armed Forces and the National Guard have made the Second Amendment obsolete. Before the court's recent entry into this debate, Congress and state and local lawmakers had largely defined gun ownership and carrying rights, creating significant variation among the states. Wyoming and Montana have virtually no restrictions on gun ownership. For example, whereas California and Connecticut have many, however, following an assassination attempt on President Ronald Reagan in 1981, a push for stronger gun control laws intensified. In 1993, Congress passed the Brady Bill, which mandates a background check and a 5-day waiting period for any handgun purchased. But not all gun tragedies led to more gun control. There were 417 mass shootings in 2019 and 464 in 2020 as of September. Defined as incidents in which at least 4 people were killed or injured, not counting the shooter, by the FBI's definition of an active shooter, there were 277 incidents from 2000 to 2018, including those in Orlando, Florida, San Bernardino, California, Charleston, South Carolina, and Parkland, Florida. In the deadliest mass shooting by a single gunman, 58 people were killed and 546 injured in October 2017 at a country music festival in Las Vegas, while 45 states have passed new gun safety laws since 2013, including smart gun laws, laws concerning mental health and gun ownership, laws restricting ownership of assault weapons, and stronger background checks. 30 states now make it relatively easy to get a permit to carry a concealed weapon, and 42 states do not require a permit. Many states have also expanded the places in which guns may be carried, including college campuses, and have passed Stand Your Ground, laws which allow gun owners to shoot first if they feel threatened. In 2008, a landmark Supreme Court ruling recognized for the first time an individual right to bear arms for self-defense and hunting. The decision struck down the District of Columbia's ban on handguns, while noting that state and local governments could enforce ownership restrictions such as preventing felons or the mentally impaired from buying guns. The court did not apply the Second Amendment to the states in this decision, but it did so 2 years later in striking down gun control ordinance in Chicago in McDonald versus Chicago, 2010, and reaffirming the ownership restrictions noted in the Washington, D.C. case. There is strong public support for gun ownership in the United States, where there are about 393 million privately owned guns. This accounts for 46% of the world's total and is more than twice as high a rate of gun ownership as in the second most heavily armed nation. There are 120.5 guns per 100 people in the United States compared to 52.8 in Yemen. The contrast to our closest allies is even more extreme. There are 34.7 guns per 100 people in Canada, 19.6 in Germany, 4.9 in the United Kingdom, and 0.3 in Japan. The fact that so many American guns support gun ownership, combined with the Supreme Court endorsement of individual right to bear arms, means that stronger gun control and the national level is highly unlikely, especially given the unsuccessful pushes after the shootings at the Sandy Hook Elementary School in 2012, and in Florida in 2016, Las Vegas in 2017, Parkland, Florida in 2018. However, the President and Congress have taken some limited steps in recent years. Early in 2016, President Obama issued an executive order requiring most gun sales to be through federally licensed dealers who would conduct background checks. The order also required the Social Security Administration to release information about mentally ill recipients of Social Security benefits, which would be considered as part of the background checks. This provision essentially prohibited people with mental illnesses from buying guns. The second part of the order was overturned by Congress early in 2017 after a mass shooting at Parkland, Florida High School that killed 17 students in 2018. High school students organized the March of Our Lives, which had 1.2 to 2 million recipients in more than 800 cities around the world. In Florida, gun control laws were strengthened by raising the age to buy a gun to 18, banning bump stocks that allow bullets to be fired more rapidly, and introducing a 3-day waiting period before buying a long rifle. Congress passed legislation strengthening the national instant criminal background check system and providing $1 billion to fund initiatives intended to enhance school safety, such as the addition of metal detectors. President Trump also signed an executive order banning bump stocks. However, the ban could be challenged in court because bump stocks appear to be legal under current law. Thus, congressional action would be required for a national ban. In addition to this limited legislative and executive action, extensive challenge because bump stocks appear to be legal under the current. Thus, congressional action would be required for a national ban. In addition to this limited legislative and executive action, extensive litigation will be necessary to define the acceptable boundaries of gun control and to identify which state and local restrictions will be allowed to stand. This is the end of part 2. Part 3 will be posted later. Thank you.